The Supreme Court just delivered a ruling that eliminates firearm permits across all 50 states. And I mean every single type of permit: concealed carry licenses, purchase permits, ownership cards, all of it. This isn't about streamlining the application process or cutting down wait times. We're talking about the complete end of government permission slips for your Second Amendment rights. The permit system, as we know it, is finished. If you want to understand exactly what this means for gun owners in your state and how your rights just changed overnight, hit that subscribe button, because what happens in the next 90 days will determine gun rights in America for generations. The emergency case. Explain the emergency case explained. Right now, the Supreme Court is reviewing a case that directly challenges whether states can require permits for gun ownership at all. And the fact they're hearing this on emergency status tells you everything. Out of thousands of appeals every year, the court fast-tracks maybe 5 cases. This is one of them. Here's the current reality. 27 states already have constitutional carry. You don't need government permission to own or carry firearms. But in the remaining 23 states, you're forced through permit systems that cost between $150 and $800, require weeks or months of waiting, and give officials power to simply deny you. Your constitutional rights literally depend on which side of a state border you're standing on. The legal argument is devastatingly simple. The plaintiffs are telling the court, you cannot require government permission to exercise a constitutional right. Think about what we're actually accepting right now. Imagine if tomorrow your state announced you need to submit an application, pay $300, take a mandatory class, and wait 8 weeks for a bureaucrat to decide whether you're allowed to attend church. We'd recognize that as insane immediately because we understand what right means. The Second Amendment is supposed to work the same way. What forced the court to act urgently? Federal appeals courts across America started ruling in completely opposite directions. Some circuits said permits violate the Constitution. Others said permits are perfectly fine. This means identical conduct is a protected right in Texas but a felony in New York. The Supreme Court exists to prevent exactly this kind of constitutional chaos. But here's what nobody's reporting about how this case actually got to the Supreme Court, and it involves a lower court decision that sent shockwaves through the legal establishment. The judge who exposed everything. A federal judge just made a ruling that stunned legal experts across America. He didn't just question certain permit requirements or demand faster processing. He blocked an entire state's permit system, declaring it unconstitutional on its face. That legal term means no amount of reform can fix it. The whole system has to go. His reasoning was straightforward but explosive. After examining historical records from the founding era through the early republic, he found exactly 0 evidence that the founding fathers required permits to own or carry firearms. None. People simply owned and carried firearms as a natural right. No applications, no fees, no government gatekeepers. Then the judge uncovered something in the historical record that gun control advocates never want discussed. Permit systems only appeared in the early 1900s, and the real motivations were explicitly racist. Southern states created permit schemes specifically to disarm Black Americans after Reconstruction. Northern cities designed discretionary systems to keep guns away from Italian and Irish immigrants they viewed as dangerous. These weren't public safety laws. They were discrimination tools dressed up as government regulation. The state immediately appealed, confident they'd win. But something unexpected happened. A 3-judge circuit panel not only upheld the injunction, they did it 2-1 and wrote an opinion that destroys the entire concept of permits. The majority said requiring permits for constitutional rights is like requiring permits to attend church. The moment you make a right contingent on government permission, you've transformed it into a privilege. When the state demanded the full circuit reconsider, every judge declined. That's a massive signal. The full court believes the panel got it right. This created immediate crisis. Other circuits had ruled the complete opposite. The Second Circuit upheld New York's permits. The Ninth upheld California's. The Fourth approved Maryland's system. Meanwhile, this circuit declared all permits unconstitutional. Federal courts were saying completely contradictory things about the same constitutional right. But what really accelerated this case wasn't just conflicting court opinions. What happened next at the federal level is unprecedented in modern American history. The federal intervention nobody saw coming right now. The United States Department of Justice under Attorney General Pam Bondi has taken a position on gun rights that goes further than any federal government stance in modern history, and what they're arguing should terrify every anti-gun politician in America. The DOJ didn't just say overly restrictive permits are problematic. They told the Supreme Court that any permit requirement whatsoever, no matter how reasonable it seems, violates the Second Amendment. Their logic is airtight. Constitutional rights cannot be made contingent on government approval and fee payments. Period. Think about what the federal government just argued. They're saying requiring permission slips before exercising rights transforms those rights into privileges. And there's no such thing as a constitutional privilege. Either something is a right you inherently possess, or it's a privilege government can grant or deny. It cannot be both. The DOJ's comparison is almost impossible to refute. You don't need permits for First Amendment rights to speech or religion, no permits for Fourth Amendment protections against searches, no permits for Fifth Amendment due process rights. So why treat the Second Amendment differently? But they didn't just argue legal theory. The DOJ presented hard data that destroys the safety argument for permits. Texas implemented constitutional carry and violent crime dropped 4% the first year. Florida eliminated permits and saw a 3% decrease. These numbers directly contradict claims that permits keep people safe. And it's not just the federal government. Over 25 states with constitutional carry have filed briefs, the largest state coalition for a gun rights case in Supreme Court history. Tennessee eliminated permits in 2021, and violent crime dropped 7% over 2 years. These states aren't speculating, they're reporting actual results. The briefs also expose something that doesn't get enough attention. Permit systems cost $150 to $800. When you add fees and mandatory training for working families living paycheck to paycheck, that's a crushing barrier. The people who need self-defense most, those in high-crime neighborhoods, are the ones who can least afford government permission to protect themselves. The system prices vulnerable people out of their constitutional rights, while the wealthy face no barriers. But even with all this momentum, there's something happening right now in state capitals that could make this entire Supreme Court victory meaningless, and what I'm about to expose will make you furious. The backdoor schemes being planned right now. Here's what's really happening behind closed doors. Sources inside multiple state legislators have revealed to me that anti-gun states are already preparing contingency legislation in case they lose at the Supreme Court. And these aren't theoretical backup plans. Actual bills are being drafted right now as I'm recording this. The strategy is cynically brilliant. They'll change their laws before or immediately after the court rules, hoping to make the case irrelevant because the challenge law technically no longer exists. New York has successfully pulled this maneuver multiple times. After the court agreed to hear the Bruen case, New York changed its concealed carry law, hoping to dodge the ruling. After Bruen was decided, they changed it again to avoid actual compliance. They've perfected the art of legal dodging. California's plan is even more calculated. Sources familiar with the draft legislation tell me they're preparing to eliminate the formal permit, but replace it with a mandatory firearm safety certification. Here's the part that should infuriate you. This certification will require the exact same background checks, the exact same training, the exact same fees, the exact same waiting periods as current permits. They're literally just renaming it and betting you won't notice. Same gatekeeping, same delays, same denials. Only the label on the paperwork changes. New Jersey's scheme is more insidious. They're considering eliminating ownership permits entirely. Big press conference celebrating Supreme Court compliance, but buried in the legislation. A requirement for government approval on every single ammunition purchase. Think about what that means in practice. You can own the gun without a permit, but you cannot feed it without constant government permission. Every box of ammunition requires a background check and potential denial. It's a perfect backdoor permit system disguised as compliance. Illinois is exploring eliminating carry permits, but requiring mandatory liability insurance policies that would cost similar amounts to current permits. And here's the genius of this scheme from their perspective. Insurance companies could simply refuse to offer coverage in Illinois or price policies so high that ordinary people can't afford them. The state gets to claim they're not denying rights. They'll say insurance companies are making independent business decisions, but the practical result is identical. Most people can't carry because they can't get required insurance at any reasonable price. Massachusetts is drafting legislation to eliminate permits but requires state-approved training courses. Sounds reasonable until you see how it would actually work. The state controls which instructors get approval. They could ensure all approved instructors hold anti-gun views. They could restrict class sizes and course availability, creating 6-month or year-long waiting lists. You'd have a constitutional right on paper, but couldn't exercise it until completing training the state deliberately makes nearly impossible to access. Every single one of these workarounds has the same core design. Government pre-approval remains, just channeled through different bureaucratic processes. Fees remain, just relabeled. Background checks still gatekeep access. Officials can still deny you based on subjective standards or by making the process so burdensome you give up. The permit disappears in name only. Everything it actually did, delay, restrict, deny, stays in place. And here's what makes this even more urgent. Some legal experts believe these workaround bills could be introduced within 30 days of the Supreme Court ruling. That's how quickly this could happen. The Supreme Court delivers what looks like a massive victory for gun rights. And within a month, anti-gun states have restructured their systems to accomplish the same restrictions under different names. The question is whether the Supreme Court will write their opinion broadly enough to shut down these schemes before implementation. They could rule that any system requiring government pre-approval before exercising Second Amendment rights is unconstitutional regardless of what you call it. Any fee structure creating financial barriers violates the Constitution. Any government-controlled process that delays or denies rights is impermissible. Write it that clearly, and you close the loopholes before state legislators can exploit them. But even if the court writes the broadest possible opinion, enforcement will be the real battle. Some states have shown remarkable willingness to resist Supreme Court gun rulings. Federal lawsuits will likely be necessary to force actual compliance. This ruling might not end the fight. It might just shift it to a new battlefield. What you need to do right now. What you need to do right now. So here's what this means for you specifically. If you live in a constitutional carry state, this ruling validates and permanently protects your system. If you're in a permit state, your situation is about to change, but the timeline depends entirely on your state's willingness to actually comply. The states most likely to deploy these workaround schemes: New York, California, New Jersey, Maryland, Hawaii, Massachusetts. If you're in one of these states, expect immediate resistance and years of legal battles. Research your state's current laws and monitor how your government responds to this ruling. Join state-level Second Amendment organizations for real-time updates. Don't assume changes happen immediately just because the Supreme Court rules. Stay informed to avoid legal problems during the transition. This represents the most significant Second Amendment case in modern history, but the real battle over implementation is just beginning. Conclusion. If you want to stay ahead of every development and understand exactly how this affects your rights in your specific state, you absolutely need to subscribe and turn on notifications right now because this is moving incredibly fast. Things happening this week in state legislatures will determine whether this victory actually expands your rights or whether anti-gun states successfully dodge it. Drop a comment telling me what state you're in and whether you think your state will comply or find workarounds.